Hi everyone, it's Lauren Con here from Con Law. Apologies for the background noise. I'm recording very briefly from Seattle Coffee because I've had some requests to discuss Oudekraal, and I had a brief moment, I have a brief moment now without the distraction of small children and so forth, and so instead of doing this at 1 a.m. I thought I would do it now. So one of the requests was that I deal very briefly with the Oudekraal principle and this idea of collateral challenges. So in a nutshell, what you need to understand is that prior to the famous Oudekraal case, the city of Cape Town, back in the day, granted approval pursuant to which a piece of land near the 12 Apostles was sold with development rights thereon. And this decision existed in fact, and subsequent decision makers proceeded on the basis of its validity. Ultimately, it was then again sold, and eventually the relevant developer wanted to develop on the property. But it was then discovered by the relevant officials within the city of Cape Town that in fact this should not have been done, because there are holy krumats, Muslim gravesite, holy land, and as such there should never have been approval in the first place. And therefore the city said no, this was an invalid decision, and as a result thereof we are not going to allow you to, we are going to treat it as invalid. And this was litigated and it went to court. And in short, what you need to understand, really just to simplify this for your purposes, is that the court said that, as you know, the rule of law, which is entrenched in our Constitution, it's a founding value, but it is a basket of prescripts in a sense. So we know that, for example, it entails the principle of legality, that all law and conduct requires a lawful authorizing source. This is obviously almost especially so in the context of public power, but you cannot just willy-nilly do as you please, right? We have law to regulate societal behavior, norms, and so forth. So there is this requirement of legality, and of course this is the aspect of the rule of law that that the city is going to be using. Well, this is unlawful, so how do we surely can't proceed? But equally, the rule of law requires certainty, right? We know that laws need to be clear, accessible, publicly available, so that people can regulate their lives, their interactions, their businesses, and so on and so forth, understanding what is required of them in advance. And of course, if this were not so, if it could be up to people, decision makers, state officials, individuals, simply to decide without more that laws are or decisions are invalid, that would almost amount to self-help. Not so, and there would be chaos, there would be bedlam, there would be anarchy, right? And so essentially in the Oudekraal judgment, the Constitutional Court held that this decision, it existed in fact, and unless or until it is scrutinized by a court of law, and we know by virtue of the Constitution that the judiciary is the ultimate guardian of our Supreme Constitution, and we know that by virtue of Section 7.2, subsection 1, when a court finds that law or conduct is inconsistent with the Constitution, by virtue of that supremacy, it must declare it to be invalid, right? It's a must. So unless or until that happens, we proceed on the basis that these acts, these laws, these approvals, this conduct is valid. Then the court has a remedial discretion. It may exercise its remedial powers in order to ensure justice and equity. So for example, if you have a marriage officer who was not properly qualified and he officiated a number of marriages, children were born of these marriages, then it subsequently comes to light that, oh my goodness, he should never have been practicing as such, and So the decision, it must be declared that his appointment as a marriage officer was unlawful, and that must be therefore set aside. Well, sorry, it must be declared to be unlawful. But the court can exercise its remedial discretion, and two examples within the Constitution are a suspension of the order of invalidity, or we can limit retrospectivity. So this is what we would do in the case of our marriage officer. We would say, well, those poor innocent people that got married thinking that this guy was, properly ordained. They've had children. The children believe they've been born in wedlock. Well, the court would likely say, we're going to limit retrospectivity. So in other words, we're declaring the impugned law and or conduct to be invalid, and in exercising our remedial discretion, we're doing so such that this order applies only prospectively. So he may no longer conduct further weddings, but all of those which he did officiate, we proceed on the basis that they are nonetheless valid, because it would be a grave injustice were they not to be treated as such. Within the Oudekraal judgment, there's reliance on Christopher Forsyth's theory of the second actor and acts that are valid in law and acts that purely require factual existence, such that subsequent acts can legitimately be made pursuant to those initial acts. I think this can overcomplicate things, so try not to overthink too much about this. I'm happy to go into it in further detail, should you wish. But for present purposes, proceed from the basis as follows, and using the example that I've given you. By virtue of the rule of law and the supremacy of the Constitution and the independence of the judiciary, we treat law and conduct as valid unless or until declared to be unconstitutional and unlawful, as it must be done, insofar as it is, by the judiciary. And so the city had to go to court to get its original authorization and or approval decision in the Oudekraal case declared invalid and then set aside, such that development could not ensue, if you understand what I'm saying. It wasn't up to the city to take the law into its own hands in that respect. It's not the final arbiter of legality. Now, there was, however, within the Oudekraal judgment, there is an exception to this rule. That's the basic rule, okay? And of course, the basic rule, I've already alluded to the way in which it can be softened by virtue of adverse implications. So once the court does declare it to be invalid, well then it can be such that all of the prior acts and or subsequent acts taken in reliance on the relevant unlawful decision may similarly be deemed void, right? Because we have a doctrine of objective constitutional invalidity, and that means that if something is constitutionally invalid, the default position, as I've said, is that, well, everything done in sort of reliance on the legal validity of that law and or decision is equally invalid, okay? That is the default. But again, when it comes to remedies, our courts have far-reaching and appropriately so discretionary powers to ensure any order that is just and equitable. Now, aside from that, when may one refuse to comply with a law and or conduct by someone, typically the state, that there is a power imbalance such that you are relatively disempowered vis-a-vis the person and or entity seeking to enforce a law that you believe to be invalid. And this is called the collateral defense exception. So, where there is an aspect of coercion meaning you're being threatened, you're being compelled, you're being coerced, and this is done in a way that impacts your life, your liberty, your property. The line in the judgment goes, you may resist with impunity. You can say, no, I'm not going to comply. with this law, these regulations, this regulatory framework, because I believe it to be constitutionally invalid. And you can take me to task. You can sue me and take me to court on the basis of my non-compliance, and I will then use the law as a shield instead of a sword. And I will challenge you collaterally by challenging that law, whatever it is, itself, and saying, oh, guess what? Actually, it flouts this provision of the Constitution, that provision of the Constitution, this provision of the Constitution, this right, that right, and therefore I was fully within my rights not to comply. That is the collateral challenge exception. So an aspect of coercion is a power imbalance, and you can then say, come, sue me, bring it, and I will show all that is wrong legally with that pursuant to which you are exerting your authority and your power over me coercively, such that my life, my liberty, and my property is adversely impacted. Now, I often give the example of I draw on the example of my second born because it's just so apt, right, in terms of when to resist with impunity. Georgia May, who was 3 at the time of the hard lockdown, when I was homeschooling my 2 eldest daughters and had just had my son, and she had overheard me lecturing the Oudekraal judgment and the remedies section of administrative law, and in particular the collateral challenge exception. And she knew, all of my children, except for Amelia, who's 1, they all have copies of the Constitution. And Georgia May knew that the requirement as per the lockdown regulations for mask wearing for children was quite obscenely, in fact, age 5, which is still when you're really very much in that early childhood development phase. I know in the UK, I think it was 12, which is far more sensible. As it happened, many children in my eldest daughter's class were, sucking on their masks, bearing in mind that she was still in grade 0 at the time, scared to eat their lunch. Mothers were messaging me saying, please write a letter because, our children are too scared to remove their masks to eat their lunch. And of course, as you know, Section 28 of the Constitution, the best interests of each child are paramount in any matter concerning the child. So it's not a globular approach. It's a context-specific approach in relation to each individual child. Now, be that as it may, Georgia May was 3, Olivia was 5, so strictly speaking, the regulations applied to her. Georgia May returned to her pre-primary school and was advised to wear a mask/face shield. And of her own accord, she, and I quote, said to the relevant educator concerned that I know my rights and I resist with impunity. And that is a perfect example of an instance in which one may, right? There's a power imbalance. She's a 3-year-old. In this particular case, not only, I think, were the regulations themselves potentially arbitrary and questionable in terms of the age limit of 5, but in any event, they were being improperly enforced insofar as 3-year-olds were not required to wear masks and or face shields. And it was affecting her liberty. It was adversely impacting upon her rights. And she was therefore fully entitled to resist with impunity. Had they wanted to sue her, well, sue me as her guardian, they could have. And I would then have challenged the law and with the application thereof, collaterally, using the Oudekraal exception. Another case of relevance is that of Zondi, Z-O-N-D-I, which is a case that concerned the erstwhile pound ordinance. Miss Zondi, for her livelihood, I believe it was cattle, I think, and they strayed onto a neighbouring property. And the neighbour in question, without really hearing her, without any adherence to the requirements of administrative justice, equality, a number of rights, simply ensure that the pound ordinance was exercised and implemented such that her relevant animals were impounded. And there goes her livelihood, right? And so what happens? She finds some nice lawyers and she wants them back. And she's in trouble, right? Because her animals have strayed onto this neighboring property, and the pound ordinance was implemented, found application, and she wanted to get them out of the pound, right? And so, in short, she says, sue me. And guess what? I am going to challenge the pound ordinance collaterally, insofar as there was an aspect of coercion, tick, and it impacted me, life, liberty, property, and it infringes a whole bunch of rights in the Bill of Rights, including the right to administrative justice, right? So this is where the Section 33 right is invoked directly, instead of going via the Paja, for example, because you're saying, well, what does this right contemplate? What does it entail? It entails that there be audi, it entails that there be legality, it entails that there be reasonableness, proportionality. We don't use sledgehammers to crack nuts. And so we're testing the legislation against a host of rights and or provisions within the Constitution, thereby challenging that legislation collaterally. And the court agreed with Ms. Zondi. And as a result, the relevant provisions of the Pound Ordinance were declared to be unconstitutional and invalid. And that is another example of the collateral challenge exception. Another case that is interesting for the purposes of the Oudekraal principle is the Ngasana judgment. You forgive me, I have an open bite, so my pronunciation isn't always the best. But you may recall it was litigated by Corruption Watch, and in short, erstwhile President Jacob Zuma wanted Mr. Ngasana out of his seat as NDPP. And he tried, there were various tactics involved. In fact, there's a line in the judgment that is penned by Justice Madlanga where he refers to what I can assume was counsel. I don't know, counsel may have said, but it was a carrot stick approach. It's like, intimidation, and then carrot stick, and there were threats. They were going to ruin his reputation and his family and his livelihood and so on and so forth. And so eventually he concedes and he settles. But in so doing, he essentially takes what is, a bribe, basically. Here's this money, go away. And in his stead is placed a Mr. Sean Abrams, who was placed there, the agenda, I'm not going to comment on that, but the point was that Corruption Watch litigated this because they wanted to get Mr. Abrams out of that position as NDPP in order to ensure that all relevant crimes be prosecuted in the public interest, no one being above the law. And so here's how we use Oudekraal 101. Number one, we proceed from the basis that decisions exist in fact and must be treated as valid and lawful and binding unless or until declared to be otherwise by a court of law. And so the court says, well, what's the decision issue here? It's the termination of Mr. Ngasana's appointment. It's his dismissal as the National Director of Public Prosecutions. And that dismissal was done pursuant to what was, in essence, poor guy, he was under duress, right? There was an element of coercion in a sense. But it was done unlawfully. It was done basically pursuant to a bribe. And he was between a rock and a hard place. And therefore, the decision to terminate was invalid, right? Doctrine of objective constitutional invalidity means that all the decisions that relied for their legal validity on that decision, all subsequent decisions are therefore, and or prior, but in this case we're focusing on the appointment of Sean Abrams, are therefore necessarily also invalid, right? Because the legal invalidity of the termination of Mr. Ngasana's appointment was such that there could not have been a validly appointed Sean Abrams in the circumstances, right? Because Sana was not lawfully removed from office. And so, in this particular case, the court says, I just lost my water. We declare it to be invalid, and we are not going to exercise. In this particular case, the court says what is needed is stability in the office. The office of the NPA is very important. They are single-handedly tasked with prosecuting crimes in the public interest. They are, as you know, provided for, the NPA is provided for in Chapter 9 of the Constitution, which deals with the courts. Sorry, not Chapter 9, forgive me, that's the Chapter 9 institutions. The provision, the chapter on the judiciary, the courts, and the administration of justice. Often there is some sort of conflation between the NPA and the executive. The NPA is not an adjunct of the executive. And in short, the court says we're declaring that dismissal to have been, it was constitutionally dubious, it's invalid. Therefore, the subsequent appointment of Mr. Sean Abrams is also invalid because it relied for its legal validity on the legal termination of Mr. Nyasana's appointment, which was not there. And yes, we could sort of exercise our remedial discretion in a way as we deem fit, but in this particular case, justice and equity are such that we need continuity, we need stability in the office, we need public confidence in the office, we need consistency, and so the court essentially said that, it's as if he was never dismissed, doctrine of objective constitutional validity, and therefore, Mr. Nyasana is back in office as NDPP. And that is a very simple, I hope, illustration of how the doctrine, of how the Oudekraal principle works. And that really it's much less complicated than I think jurists, lawyers, judges, people make it out to be. It's really quite simple. So let's summarize. We proceed from the basis that all decisions exist in fact and should be treated as valid and binding unless or until set aside by a court. We can't resort to self-help. We live in a rule of law state. There would be anarchy, and we need legal certainty. At the point at which the judiciary brings its mind to bear, and it says, indeed, there is non-compliance here with the tenets of the Constitution, it must, by virtue of Section 172, declare the law or conduct to be invalid to the extent of the inconsistency. The default of doctrine of objective constitutional invalidity is such that all related decisions taken in reliance thereof and all pursuant thereto are also invalid, right, insofar as they're required, they rested upon the legal validity of that Pune decision. And therefore, it's like, poof, they never happened. But I gave you that marriage officer example, and I said, sometimes courts will say, you know what, while this particular act is invalid, subsequent decisions is flowing therefrom, and or, the various marriages flowing from this dude's appointment as a marriage officer, we're going to say that this order does not apply retrospectively, and that those marriages were nonetheless legally concluded, and or marriage contracts were legally entered into, or it would just not be just and equitable. The consequences would be dire, could be potentially heinous. And the collateral challenge exception, which also arises in Oudekraal, is simply that, yes, the default is we proceed and we comply with the law, save where there is an element of coercion. In other words, there is inequality of arms, lack of bargaining power, and the weaker entity of the two feels coerced by virtue of a law that infringes his or her life, liberty, or property. He or she may resist with impunity, say challenge me for non-compliance, and then use the law as a shield, essentially, and challenge the law pursuant to which there was this act of coercion on whatever basis it may be. But of course we know that all law and conduct has to be constitutionally congruent. So in Ms. Zondi's case, she would say, well, this pound ordinance makes no provision for a judicial officer to weigh in. It affects my right of access to courts, it affects ministry of justice, it affects even indirectly my right to equality, right? Because I am a woman of color, trying to make a living for myself. But these animals, they were taken away from me without me even being heard, and so that's invalid. So fix the pound ordinance. And that is the collateral challenge exception. I hope that you have managed to hear this between coffee grinding and background conversation. But as I said, we seek always to keep it raw, real, unfiltered, from the heart, from the mind, from me to you. And as per the request, I hope that this has sufficed in terms of the supply meeting the demand. Please do let me know if there's anything else that you require clarity on, and I'm wishing you all a wonderful day further. Bye.